So, good afternoon, everyone. I just want to say welcome to our Faculty of Law Research Seminar. And the title of our research seminar is Music Copyright Ownership, Factors Behind the Increase in Writer Credits and Rights Clearance. And our research seminar today is going to be chaired by none other than our very own Dr. Emma Pearl, who is a lecturer in law of the University of the West Indies, St. Augustine, Trinidad and Tobago. So for Emma's bio, Dr. Emma Pearl is a lecturer in law at UWI St. Augustine. Emma received her PhD in intellectual property from King's College London, where she was a fully funded Dixon Poon Scholar. Prior to this, she obtained her LLM, which is her Master's of Law in IP, Intellectual Property, with distinction from UCL. Her first book, Commercializing Celebrity Persona, Intellectual Property Law and Practice, was published in 2023 by Hart Publishing. Emma's research has yielded publications on AI, deepfakes, and NFTs. She was awarded the Most Outstanding Faculty Researcher for Law at the UWI Principals Research Awards 2023. So that is our very own Dr. Emma, who is going to be presenting her article today. And now I'm going to read for you an abstract of Dr. Pearl's article. So as I mentioned before, it is entitled Music Copyright Ownership, Factors Behind the Increase in Writer Credits and Rights Clearance. So this is Dr. Emma's abstract of her article. The music industry has gone through a period of rapid change ushered in by the digital era. Changes in the way music is made include more active involvement in song creation by producers, the use of songwriting camps, the practice of artists taking credit even with minimal creative input, and the popularity of sampling and interpolation. Notwithstanding the evolution of these practices, there have been allegations that recent copyright infringement cases, namely the Blurred Lines case, Williams versus Gay, have had a profound impact on the creation of music. However, this allegation ignores the fact that prior to the Blurred Lines case, there were significant music copyright cases that have considered originality, subconscious copying, inverse ratio rule, and bright line standards that have shaped the approach to music creation and licensing since 1976. To prove that the impact of the recent copyright infringement decisions have been overblown, this article by Dr. Perot analyzes the year-end Billboard top songs from 1946 to 2023 and shows that the number of songwriters per chart-topping song has increased from an average of approximately 2 in 1946 to an average of 4.4 writers in 2023, with a steady increase over time. One of the major factors is the increasing popularity of hip-hop and rap, which often involves sampling and interpolation, and involve the producer in the creative process. The genres of music from 1946 to 2023 are charted to demonstrate that the popularity of these genres rose to prominence in the 1990s, around the same time that Grand Upright established the Bright Line Rule. Therefore, the music industry has been affected by this major development in the law and simultaneously listening preferences. While some songs do indeed credit writers to avoid litigation as part of the blurred lines effect, these songs are often the most successful and thus receive a high level of media attention. So this article makes a new contribution to the field by creating a timeline of key music copyright cases and music industry practices, and assessing these factors against the increase in the number of songwriters per chart topping song to provide a holistic picture of the music landscape from 1946 to 2023. This research is important because overemphasis on recent case law fails to consider other factors that have shaped the music industry and some of the broader issues that have arisen because of the average increase in songwriters per song. Namely, career songwriters have negatively been impacted by this trend, as more writers means less revenue per person. The change, the word take a third trend, has been objected to by a group of songwriters called the Pact. The data demonstrates that in 1959, in the nascent stages of the Billboard Top 100, 30% of songs credited the artist as a songwriter. In 2023, a whopping 88% of songs credited the artist as a songwriter, validating the concerns of the pact. This issue is exacerbated against the background of streaming, where the revenue share for these songwriters is smaller than previously received from physical sales. Understanding both the legal and non-legal factors that have contributed to the trend is vital for aiding songwriters in their fight to receive equitable remuneration. So it sounds like a very, very interesting and fascinating article. So at this time, I'm going to hand you over to Dr. Perot as she conducts her research seminar. Dr. Perot?
Thank you so much for that, Grace. I'm very excited to be talking about this topic today because it's a topic, while versed in law, it's one that people are quite interested in because we all listen to music, whether it's on the radio or Spotify streaming services. We all have our favorite songs. Now, some of the more popular songs in recent years have had a high number of songwriters, and this is what got me interested in this topic. So, for example, Travis Scott's Sicko Mode, if you listen to that song, it does sound like multiple songs have kind of been sliced together. That song credits 30 writers, and that is largely because songs are in fact sliced together by sampling and interpolation. Beyonce's Alien Superstar, and in fact, many of Beyonce's songs have a large number of writers because of the team process she uses in that songwriting. Similarly, Morgan Wallis's Love Somebody, which was previously number one in the Billboard Top 100, had 6 writers. The current number one, however, as of today, is Tipsy by Shabuzi, and that also has 6 writers. So, because of the large number of songwriters, there were quite a few magazine articles that came out in music magazines talking about how these big songs, because these songs tend to be top 10, even higher than just the regular top 100, they are the real chart toppers, have a large number of songs. So that got not a large number of writers. So that got me interested as to, well, why is this happening? Because the songs that become the most popular, it's not to say they have great lyrical depth or anything like that. We all know pop songs tend to be fairly repetitive, and songs are even quite short these days, some of them. So why are there so many writers, and what is the role of the law as well as non-legal factors? Because I always like to see what is this interface. It's usually not just the law operating in a vacuum. So in doing this, I started to learn about the increase in number of songwriters. This prompted this research. And I also learned that accompanying this increase in writers was a problem articulated by career songwriters. That is that number one, they are making less money in the age of streaming because of how the revenue is shared. And number two, where there are more writers, then they have to share an even smaller pool of money. Compounding that is where there is potential for infringement. So there might be an accusation, might not even go to full lawsuit. More writers might be added, and then that again reduces the amount of royalties available per songwriter. So all these things have come together to make it very difficult for career songwriters to make the type of living that they would have previously. Because the magazine articles that I looked at really just focused on recent years and had very small sample sizes, I decided that I wanted to conduct more in-depth research, and I'm grateful to the University of the West Indies St. Augustine Campus Research and Publications Fund because they provided funding for me to collect this data. Using a team of 9 UE undergraduate law students, we were able to collect data on the Billboard Top 100 from the time the record started to 2023. Of course, 2024 annual chart is not out as yet. So the record started in 1946 thereabouts. That's the annual records. And the annual records weren't 100 songs until 1959. So before that, different numbers of songs were recorded as the top songs, usually between 30 and 50. So it's in 1959 that we have the full spectrum of the top 100 year-end charts that we all look at to see who has kind of emerged victorious in this music battle on an annual basis. So we were able to collect the songs themselves, so the names of the songs, We went to two main music databases, that's ASCAP and BMI. Those are organizations in the US with online platforms. We were able to search all the songs and see how many people were credited as songwriters. We were also able from that data to see is the artist credited as a songwriter? And that took a lot of labor-intensive work by the students because not all artists perform under their legal name that might be listed as a songwriter. On top of that, we were able to figure out using a website called Chosic what genres the song might fall into so we could trap the preference, the listening preference of the music. From this data, we learned quite a few things. This first chart here shows that there has indeed been an increase of songwriters per hit song since the Billboard annual charts started. The most marked increase happened in 1991. So before 1991, you'd have less than three songwriters credited on average. And after that, it was more than three, and we see the chart increasing as time goes by. When I get to the timeline of the presentation, we'll see that the 1990s was a very significant time, not just in the legal sphere, but in the way that the music industry was operating in terms of their use of technology, their changes in preference for certain types of sounds, as well as the collaborative nature of the industry. Something that happened in the 1990s that's quite significant is that rap and hip hop became more mainstream. So while rap and hip hop kind of started in the 1970s, gained traction in some communities in the 1980s, it went mainstream, so a more diverse appeal in the 1990s. Rap and hip hop have traditionally always used pre-existing songs. In other words, you may have heard of sampling and interpretation. Rap and hip hop generally would use something that came before and built upon it. Now, strictly speaking, under copyright law, this could be copyright infringement because copyright, as the name suggests, is a right against copying. So if you're copying somebody else's song and adding on to it, you might be infringing copyright. Until rap and hip hop became mainstream, copyright law was not really a big concern. However, around the time it became mainstream, a case was brought that actually made a big change in the landscape because it confirmed that this type of sampling and interpretation could indeed be considered copyright infringement. So while genres are becoming mainstream, copyright law is also intervening. So the large number of writers in relation to those genres can be reflected by two things, both the copyright change and the fact that it was always the norm to use other songs. It just became clearer that you now had to credit those writers. To show how rap and hip hop increase with popularity, I have this chart, and if you are interested in seeing all the genres that have been classified, you can check out my paper on SSRN. That's the Social Sciences Research Network. It has the pre-publication version of this paper, so if you just search my name and SSRN, you'll find it. The actual published version is going to come out next year in the Berkeley Journal of Entertainment Sport Law, and I have more charts in it, including the one that talks about all the genres. But this one talks about rise of rap and hip hop. And we do see that the 1990s, this is when this type of music is really becoming popular. So, two things are happening in the 1990s. First one, in terms of law, is that Grand Upright, which is the name of a case, established the bright line rule. Now, this case was not particularly well reasoned, but it was still significant because generally the music industry is going to be risk averse. They don't want to spend a lot of money on law when they're trying to make money from music. So what happened in Grand Upright is the court said if you are sampling, so you're taking an existing sound file or you're interpolating, you are recreating already existing music, you will need to clear those rights. In other words, you need to seek a license. In music, this usually means you're going to credit the earlier songwriter. So if the earlier song had three songwriters and you are now working on a new song with two songwriters, you're going to end up with six because you have to account for the earlier song. This is significant because rap and hip hop generally by their nature include samples and interpolations. So while the practice was always that you'd have this multiple use of songs, Grand Upright made it very clear that while you are doing this, you do need to clear the rights or you are at risk of copyright infringement. Within this time as well, we're starting to see a shift in music consumption. So we went from physical sales to digital downloads. And of course, in nowadays we have streaming. Streaming has become the most preferred source of accessing music since about 2018 or so. In the last few years, it has overtaken every other type of sale. Now, significance of this is the way in which the royalties are calculated, very different from the physical sales. So physical sales, there was one calculation. This type of sale was less beneficial when it changed to digital downloads, and royalties have yet another different type of calculation. I won't go into the details of the actual calculation, but the takeaway point is that the songwriters are actually getting money from a lesser share. So while the music industry seems to be making a lot more money from streaming, in fact, records are being broken every year. So production houses are making more money. The songwriters are actually making less because of the way these calculations are taking place. Another thing that we can observe from the data is that artists are now more often being listed as songwriters. So, as Grace mentioned, in the past, you would have an average of 30% of songs listing the songwriter. Now, it can be that artists are generally helping write their songs, but that is not usually the norm. And in fact, songwriters and artists used to be very different careers. So while we all love to romanticize this idea of a singer-songwriter, particularly in these very, very popular chart-topping songs, that was not really the norm. It's still not the norm, but what we have seen is the rise of the trend of write a word, take a third. This basically means that an artist might have minimal creative input, but they are still taking writing credit. And they are taking writing credit because they can make more money. Now, this is partly due because of the shift to streaming, which has also impacted artists. But this trend actually started, or at least was allegedly started by Elvis's manager. So Elvis's manager famously used to insist that Elvis was given songwriting credit, even though he had next to nothing to do with the actual composition of the song. He performed the song, of course, but he didn't actually write it. So controversially, he really kind of cemented that practice, and it has grown significantly. So now most songs, as you can see from this chart, are in fact crediting the artist as the songwriter, even though they might have very minimal input. Another thing that's happening in the 1990s onwards is that we have a change in the taste of music. So older songs, key changes were a very common type of feature of the music. We don't really have that as much anymore. So key changes have become obsolete, which means there's less variations in the the music being produced because they have to meet the taste of the audience. As a result, there is this tendency that sometimes old things will be reproduced, and that does implicate copyright law. In addition, though, there's also this taste for nostalgia. So I'm sure if you listen to the radio, you'll know that a lot of songs that you're listening to have drawn reference to earlier songs. So even the song that I mentioned that is now number one, which is Tipsy by Shabuzi, that song interpolates um, Tipsy by Jay Quan, which is a 2003 song. And there are countless examples of this where you're listening to a song and you say you know this song. That is because there is a very deliberate move in the music industry to bring back these old songs, but also appeal to the new audience. So, in terms of appealing to the new audience and the old audience, the younger generation is hearing new music to them, but the older generation, and we're not even talking that old, we're talking about millennials onwards, are hearing songs that resonated most with them. Because while outside of the scope of this research, other psychological research shows that people tend to develop their music taste in the adolescent years, and after that, they become less receptive to new music. So if you really want to captivate this market, you need to get a wide net, and the music industry has realized that. So there is a deliberate inclusion of old songs into these new songs so that the old song gets more play because now the younger generation is hearing it for the first time. And then the new song also gets play because the older generation is interested in the song. So this creation of nostalgia is a very deliberate move by the music industry. And in fact, the songwriting camps have been introduced that specifically ask the writers to incorporate existing music catalogs. In terms of this reuse of old songs, Charlie Harding has created this graph that I have reproduced with permission based on the use of interpolations on Billboard year-end Hot 100 songs from 2010 to 2019. So if you're interested in looking at his work, he and his podcast partner, they operate a podcast called Switched On Pop. You can just search Switched On Pop. It's a very useful podcast if you're interested in music. They touch on all areas of music. And he also has a book. They both wrote this book, which has been very useful in my research that you could follow through looking at the website or looking at this QR code. The point of this graph, though, is to show that there indeed has been an increase in songs with interpolations and samples. So even more so as we get from the 2010s onwards, which is why you hear a lot of these songs being repeated, this becomes even more popular. The difference we're seeing, though, is that in the 1990s, sampling and interpolation would have been very popular in rap and hip hop because that was the history of those genres. That is how they were always made. That's not really how other kind of general pop songs were made, but that tends to be the trend now. So that practice has permeated other genres because of this need to create nostalgia. So while in the 1990s we started to see the sharp trend because of rap and hip hop, this trend is sustained because the practice is now very common across genres, particularly those that are reaching the Billboard Top 100 year-end charts. So there are two main causes for all these changes that we are seeing. One is the role of copyright law, and the second is music industry practices. So what I'm going to do now, we've talked about some of these changes, but I'm going to map it out for you on a timeline. So we see, of course, the 1990s is big on this slide because that is where a lot of the changes were happening. But if we look at the music industry, a lot of things happened. So in the 1960s, change the word take a third. That is the practice by Elvis's lawyer, not lawyer, sorry, you would think it's his lawyer, or Elvis's agent, where he was saying, well, if you want to get Elvis on this song that you have written, you need to credit him. Quite unethical, but this has now become the trend. In the 1970s, we didn't have anything big going on in the music industry, but in law, we did have a significant copyright case. In fact, two copyright cases. One was Bright Tunes Music and Harry Songs, and the other was the Sid and Marty Krofft case. Now, in Bright Tunes Music and Harry Songs, they established a subconscious copying rule. What that means is that you do not have to have an intent to infringe copyright. So, if you heard a song, let's say 10 years ago, that song is in your subconscious. You may unintentionally reproduce some elements of this song. Even though you didn't mean to do it, you can still be liable for copyright infringement. Now, of course, this is very risky if you are a musician because musicians naturally listen to a lot of music. They've listened to music for their whole lives. That's the base of their career. But the fact that subconscious copying can lead you to infringement, even if you didn't mean to do it, of course, opens you to a lot of risk. So there was that issue. And there was also the inverse ratio rule. The inverse ratio rule is this copyright principle whereby the more identical, or rather, the more similar the songs are, the less evidence you need of accessing the song. And that was very problematic because you are kind of equating similarity to protection, and that's not how copyright law is meant to work. Copyright law protects against copying. It does not protect a concept. So it should mean that if there are two songs that are independently created and just coincidentally sound the same, that there's no copyright infringement unless there's a link between these songs. In other words, the person who created the latest song must have accessed the earlier song. This access standard is changed by the inverse ratio rule because it gives a presumption of access, and that presumption increases the more similar the songs are. So that's a little difficult as well because with the change in key taste that come later on, or rather, don't the disregard for the change in key taste, there are more limited combinations of note that can be pleasing to the ear. So you are having greater similarity, and that shouldn't really result in copyright infringement because that's not what copyright's meant to protect. That being said, thankfully, the Led Zeppelin case finally overruled this rule, but it was very recent, so we haven't really seen the effects yet because that rule has been around for a very long time, so it takes a while to see these changes take effect. In the 1990s, as I mentioned earlier, we had two big things happening, or rather, we had multiple things happening in the music industry. One big thing in law is grant upright, where if you sample, you need to credit. But in the 1990s, a lot of things are happening in the music industry. So key changes are becoming less popular. Songwriting camps are being used. So these are groups of songwriters who are put together by usually the music studio. And they are told you need to create songs, you need to create music for either a certain record or because they're going to shop them out to different artists. So obviously, if you have people coming together deliberately creating, you will have multiple writers. We have MP3s, the good old days of MP3s being created, so new consumption of music. We also have digital technology for music creation, so the way in which music's being made becomes a lot more accessible, a lot easier, but also you have more people taking part because the producer becomes very integral into the actual final song. Eventually, we have streaming overtaking the physical sales and the back catalogs coming in. So all these things are just kind of continuing into the 2000s, 2010s, and 2020s. We have YouTube coming about. We just kind of have this established practice now that samples are going to be cleared because you don't want to have any risk, even though grant upright was not particularly well articulated. The music industry is going to be risk averse. And then in recent years, while we've also had streaming definitely cleared the way for the most preferred way of accessing music, alongside that, we've had some things go on in the copyright litigation sphere. So very famously, the Marvin Gaye case, there were a large amount of damages awarded in that case. This is even though that case by itself was heavily criticized. And in fact, it wasn't the only copyright case to have a very large amount of damages. It got a lot of media attention. Because of that, we've had an increase in risk mitigation practices. But as we see, things are going on in the music industry that is leading us to a large number of writers anyway. So the back catalog sales, the camps for music interpolation, and just in general increase in interpolation and sampling. All those things are leading us to a large number of writers, but these are happening right alongside the developments in law. So we have two things that we can look at. We have on law, we have risk mitigation practices. You don't want to lose money over the song that's meant to make you money, and you also want to protect your reputation. If you are an artist and you get accused, because it's really the artists who are the front facers, not really the songwriters, you get accused by a songwriter of ripping off their song, that doesn't look good. So sometimes if you're a big artist and you have the revenue to do so, you're just going to add these people to avoid any type of drama. Now, as the big artist, this probably isn't going to negatively affect you that badly, but it will affect your songwriters who you've already probably taken some of their revenue from by adding yourself if you didn't even participate. On the practical side, we also have this whole revenue issue where labels want to make more money. That's always what the music labels are going to do. And all those changes in the music industry have been geared to generating more money. So these very practical changes are happening. They're happening at the same time as law. But I think it's important to recognize these practical changes. And that is because not every song is going to be the subject of litigation. Not every song is going to get sued. So while we have risk mitigation, it is not the law in itself, or by itself rather, that is causing this shift in the industry. There are other things that are taking place. For example, those songwriting camps, the tastes changing in music, all those things are very practical things that the law is not really causing to happen, but it is happening alongside the law. In terms of what all this means in practice, so career songwriters are earning less revenue, and this is being exacerbated by the Birdlines effect, where we have more risk litigation practices, but not every song is subject to an infringement allegation. So there are only certain songs, usually the most successful, that are going to get this type of allegation. That being said, despite the limitation, and in fact, if you look at the case law, a lot of recent cases have actually gone in favor of the artist. That case got a lot of media attention, and the effect of that is really to make people very nervous about how they are approaching any potential claims. But the changes in the music industry also need to be accounted for. So because we have these practical issues, as well as the legal issues, we really need a full picture there to address this issue. Because if we don't have the full picture and we place too much emphasis on one side or the other, then we're probably giving more weight to blurred lines than needs to be given. This is particularly that after blurred lines, yes, that was a significant case in terms of the damages awarded. But since that, Katy Perry was successful in defending her case, and Ed Sheeran was successful in his case as well in the US. It's just that that blurred lines case really seemed to rock the industry. The players involved were very big, and the media really gravitated towards it. So even though we had these later victories, this risk mitigation has continued, but of course, it's continued alongside things that were already happening in the music industry. So then, what does this mean for career songwriters? How are we going to help them? Well, in terms of the legal side, I think we do need some re-education on the significance of the blurred lines case because I think there are some overly protective risk mitigation practices happening. Those will take place usually with the most popular songs. They don't want any accusation against them as the artist because it affects their reputation. And sometimes because they already have the financial backing anyway, it makes sense to, as we would say, take in front. If you take in front, being front, front take you. You can save more money in the long run, right? But that's as the artist. That doesn't really work very well if you're one of the songwriters who's a career songwriter. Your revenue has already been decreased, and now you are at the whims of people making claims, which might not even have the best legal basis. So we need some more re-education on the significance of blurred lines, especially because we have had subsequent cases that have gone in favor of the defendants, particularly Katy Perry and Ed Sheeran won their cases in the end. We've also had positively in the law the overruling of the inverse ratio rule in the Ninth Circuit. Because that was very recent, though, will take a while to see those effects, but that's a positive change. In terms of the music industry, many of those changes are taking place even without the influence of law. So, unfortunately, many of those changes probably are here to stay. So, things like the songwriting camps, that collaborative production, that's probably not going anywhere. Things like the deliberate use of samples and interpolation, that is only increasing. I suppose eventually we will see a point where the taste is just not as receptive to that type of music making, but right now that is what is very popular, so that's also here to stay. The real thing that should be changed, and is difficult because it requires a lot of negotiating power, is the practice of the artist taking credit, where most likely in many cases they weren't actually deserving enough credit. So I want to come back to this graph here because this really goes to this one. So while we saw generally that there's been an increase in number of songwriters per song, there are many things that could account for that, including the sampling, interpolation, songwriting camps. All that legitimately would probably require multiple writers. But the fact that artists have so sharply risen in their representation of songwriters in terms of their being credited is very problematic. And this problem has been felt to by the songwriting industry. In the US, a group of songwriters called the Pact released a public statement saying that they're not going to give credit where it is not due anymore because it's really impacting their income, which has already been impacted by the impacts of streaming. The frontman of One Republic, Ted Ryan, or Ryan Teddy, cannot recall his name, but the point is he's not only the frontman of One Republic, he's also a prolific songwriter. He's written a lot of hits. And he has said publicly that artists will come in and say that they want 20 or 30% of a song that they have not written. They've had very little or no contribution sometimes. So the fact that we're seeing this sharp increase is significant because it tells us that artists are getting this songwriting credit where they probably should not be. And yes, there will be cases where the artists are involved. Taylor Swift is known to be actively involved in her songwriting. But in other instances, artists are not involved, but they are exerting pressure on career songwriters to credit them. And because the career songwriters are already being squeezed by the way that they're getting revenue through the change in models to streaming, sometimes they have very little bargaining power because if you have a big artist asking you for credit, it's very difficult to say no, which is why the Pact is a group of career songwriters who have come together and they said, we're going to band together and stop this. So this is really something that the songwriters have control over. That control is, of course, limited because if you are, let's say, a new songwriter, you're not very well known, you want your song to become popular. So if a big artist approach you, there's probably not much you can do. But ultimately, that is something that can be changed and something that should be changed. In terms of the law, we have had positive developments with the overruling of the inverse ratio, but we definitely need some music industry re-education on the significance of blurred lines because it's not even the most significant music copyright case. Grand Upright, I would say, was much more impactful in terms of what the actual effect is. But with music re-education as legal significance, we can see perhaps different practices. That being said, the music industry, as we have seen, has gone through its own changes alongside the law, sometimes influenced by, but sometimes independently of. So most likely, we're not really going to see any type of sharp decrease in the number of songwriters per song, but hopefully with this information, it's now clear as to what the focus needs to be in terms of the re-education, but also in supporting the songwriters, because the data does show that artists are now more frequently named, and hopefully this data will be useful in their negotiating strategies so they can retrieve more equitable remuneration. So this is my research. Thank you once again to the University of the West Indies St. Augustine campus for providing the funding for this data collection. The data consisted of over 7,000 songs to make these charts, and you could get the pre-publication version by scanning this QR code. You can also add me on LinkedIn as I often share my research there. So thank you very much for this. And if you are looking at this on YouTube, please check out the SRN paper, or you can wait till next year when the paper will be out in the Berkeley Journal of Entertainment and Sports Law, Volume 14. So thank you very much. That is my presentation for today. If there are any questions, you can ask me now, and if not, we will end the presentations. Okay, so I'm not seeing any questions. So I'm going to end it now, and the recording will be uploaded to YouTube if you want to review it. So thank you so much, and thank you to the faculty for hosting me today. Thank you, Grace, for that fantastic introduction to both me and the paper. And I hope this was informative and enjoyable for you all. Right, thank you so much.